Dear participants, good morning once again. My name is Yulia. I represent the company Webinar.ru, and today I provide the technical support of the event. Could you please once again write in the chat if everything is okay with the sound and video? If there is any problems or questions during the webinar, please write about it in the chat. Okay, thanks for feedback. If everything is all right, I would like to start the webinar then. Let me introduce our speaker today, Mr. Vladimir Birulin, partner, chief lawyer of Gorodissky and Partners. Vladimir, you have the word.
Oh, thank you, Yulia. Hello, everyone. We're very glad that there are so many participants today. Today we shall discuss enforcement of IP rights in Russia. Now, whenever the issue of IP rights crops up, we always hear that sometimes enforcement is not good in Russia or any other opinion. Therefore, this time we decided to dedicate this webinar to the enforcement issue, how it goes on in Russia. This is a provision from the TRIPS agreement. You know, perhaps that Russia has been joined the WTO, and now we expect that the Russian Parliament will ratify the accession to WTO, and along with the accession to WTO, we shall have to comply with several international agreements. TRIPS is one of them. Even though we are not yet a member of TRIPS, we have been for a long time compliant with the provisions of the TRIPS agreement. So let's talk about the legislation. In order to protect the rights, we must have the legislation, the law enforcement bodies, clear procedures, and inevitable and adequate punishment. When those four constituent parts work in harmony, the IP rights can be protected. If we talk about the legislation, the first instrument that we have to mention is the Civil Code Part 4. Certainly the Civil Code contains also parts 1, 2, and 3. Part 1 contains some general provisions which govern in general economic life in Russia, and Part 4 was added relatively recently in 2008, and perhaps the fact that it was added to the Civil Code underlines the fact that the Russian government attaches so much importance to intellectual property. Aside from that, we also have a code on administrative offenses, criminal code, and a couple of other laws which allow us to deal with the infringement cases in different situations. So, correspondingly, we have the remedies. If we find an infringement case, we may act along different lines of action. We have a civil line, administrative line, and a criminal line of action to deal with infringement. We also have law enforcement bodies. These are anti-monopoly body, the customs, the police, and the court. When the preceding three bodies investigate and persecute the infringer, all the same, they will draw a lawsuit and file a suit to the court, which issues eventually the judgment. Let's talk a little about the Russian system of courts. We have two branches of courts, the commercial courts and common courts. The commercial courts are called in Russia arbitration courts. Every branch of courts have four instances: the first instance court, the court of appeals, and so on. So we may be sure that in any case the rights of the IP owner will be properly protected. The commercial disputes are mostly among the legal entities, and the common courts are the proper venue for the solution of the conflict, where one of the parties is an individual person. One of the most important developments in the recent times has been the introduction of the Intellectual Rights Court. It is scheduled to begin operation next year in February. We shall see whether they will come up to our expectations, but at least it is scheduled to begin work on February. The Intellectual Rights Court will consider the issues associated with intellectual rights. As a first instance court, it will examine the cases regarding the validity of the rights, and if there is a conflict with the patent office with regard to the examination of IP subject matter. As a cassation instance, it will consider infringement cases. When it begins its operation, we shall see how it will work. As I have already said, the IP court will consider the cases as a first instance court and as a cassation instance, and a very important constituent feature is that, unlike the situation today, the Intellectual Rights Court will have technical experts on the payroll, so they will be participating in the hearings and will give advice to the judges. The location of the court will be Skolkovo. This is a suburb of Moscow. In order to make the system of protection of rights more flexible, Russia has also a law on mediation. It has come in force 1 year ago, and it provides that mediation shall be conducted on mutual agreement of the parties. The law has a number of provisions which allow the parties to participate in the proceedings and come to a solution acceptable for both parties. For the sake of justice, it has to be noted that so far this type of solution of the conflicts is not very popular in Russia, perhaps because the law is very young and the economic entities just did not work out the habit to participate in the solution along these lines. So when we find an infringement case, what has to be done? The first idea that comes to mind is that we should send a cease and desist letter to the infringer. Our experience shows that this is the most quick and cost-effective way to deal with the infringer. Our experience shows that we have success in 20 to 30% of cases when we simply send a letter to the infringer. The experience also shows that when the IP owner himself sends a letter to the infringer does not react positively in all cases, but whenever a law firm sends such a letter to the infringer treats it seriously. When the infringer does not respond or responds negatively, this also is very useful information for us because we know what we have to be prepared for. In that case, we take it seriously and prepare ourselves to fight in court. This is one of the cases where we have had a case of infringement of a trademark. On the right, you will see the fake product, which was manufactured by the infringer, and on the left is the original product. When we wrote a warning letter to the infringer, he immediately yielded and agreed to destroy the infringing product. And here on this picture you will see how he himself participated in the destruction of his counterfeit product. And this is a rather frequent case. We have many examples of this kind. Now we go to the civil action. As I have already noted, we have several lines of action. One of them is civil. When we file a civil suit, we have a number of remedies which we may claim in court. In the first place, it is recognition of right. It's very simple and obvious. But in most cases, when a plaintiff files a suit to court, he demands cessation of the activities of the infringer. And he always or sometimes claims damages. With regard to damages, it should be noted that the courts are very strict in demanding that the plaintiff confirms the amount of damages. The courts very strictly verify the documents which are submitted to prove that the damage is indeed in the amount that the plaintiff claims. This is not always easy. Therefore, the law provides for compensation. Compensation does not have to be proved by the plaintiff. He simply claims it in court, and the court either awards it or moderates it to some lower level. It is also necessary to note that compensation today may be claimed in case of a trademark infringement. As for the patents, today we do not have such measure today, but there have been some amendments which have already been prepared, and they will be soon adopted by the Russian Parliament, and the patents will be placed on the same footing with the trademarks, so that very soon, after several months, compensation will be also available to the patent owners. Another very important claim which can be made in court is to destroy the infringing products. This measure has been available for quite a time, but a couple of years ago an amendment was introduced into the Russian law so that now equipment which was used for the manufacture of the infringing products can also be destroyed. And at last, liquidation of a legal entity is available when it is gross infringement or repeated infringement. If we talk about the time span required to conduct the civil case in court, it takes approximately 4 to 5 months to obtain a decision of the first instance court. Now let's have a look at some statistics. In the upper chart, you will see the civil cases handled by the Russian courts. You will see the twin columns. One is taller, another one is lower. The blue column shows the cases handled by the commercial court. As I already said, the IP disputes are mostly handled by the commercial courts because the conflicts happen mostly between the legal entities. The common courts handle those disputes only where there is an individual person is one of the parties. If we have a look at the table which shows how many cases are over the years, you will see that the number of the cases over the last years has stabilized around 3,000, which means that the number of infringement cases or court cases has reached a point of saturation, and we may expect that it will remain at approximately this level for some time to come. You will also see that before 2008, there was a steady growth of IP cases. I can explain that by the fact that at that time, in the years 2000 and onwards, the Russian legislation in the field of IP was developing, and also the IP owners were getting habit to protect their rights. If we have a look at this table, infringement cases handled by commercial courts, we shall notice that the most number of the cases concerns copyright. Why does this happen? This is because the copyright is very easy to infringe. And with the advent of IT technologies, it becomes especially easy. As for the patents, we have the least number of the patent infringement cases in courts, and this can also be explained by the fact that a patent is always a complicated technical device and it is not easy to infringe it. One has to make some investment to make infringement, while the number of the trademarks is much more high, and it is enough to buy a consignment of goods to bring them to Russia and sell. Therefore, it is also clear that it is much more easy to make a trademark infringement. And correspondingly, if we have a look at the last table, we shall see that the Russian courts award quite high figures to the IP owners. So when we find infringement, what do we have to do? In the first place, we have to collect evidence of the infringement. Collecting evidence is not easy as it may seem. It is not simply possible to buy an infringing article and bring it to court. When we buy an infringing article, we always demand a special invoice from the shop that would show that who sold it, when he sold it, and what he sold. If we have such an invoice, it will be possible to produce it during the hearing of the court. Also, we take decision at this time whether we should send a cease and desist letter to the infringer. But first, certainly we have to collect and document evidence. Aside from buying an infringing article, we may collect all pieces of evidence. For example, we may collect advertisement from the infringer where he offers for sale his infringing products, or we may attest or verify the website with the assistance of a notary public. We may collect any piece of evidence which would show that the infringement indeed takes place. Cease and desist letter is not a must in our case. It is possible to file a lawsuit without sending such a letter, but practice shows that sending a warning letter is always useful, and we practically do that in all 100 cases when we handle an infringement case. Also, we have to draw up a lawsuit with the arguments in support of our actions, in support of our action and claims. How we collect evidence? As I have already said, evidence can be any piece of information which will prove that the infringement is indeed taking place. Very often, the IP owner himself or his representative in Russia collects such evidence and provide it to us, or when it is not easy or for some reason the IP owner does not do that himself, he may request that from his local attorneys, and we indeed very often participate in collecting such evidence. Also, if some evidence is not easy to come by, we use the services of local investigators who will help us to collect some evidence. It is also important to notice that the court will accept only that evidence which was obtained by lawful means. Sometimes we may obtain information which cannot be produced in court, but nevertheless it may give us a lead to obtain some other information which can be produced in court. So, when we file a suit, the litigation starts from filing that suit. Also, when filing the suit, we must pay a government fee, and the amount of that fee depends on the scope of our claims. When the court receives the claims, the suit, the court checks it for formal requirements, and if everything is okay, the court schedules the date of the preliminary hearing. The date is scheduled as a rule within the time period, approximately a month. For the most part, it depends on the workload of the court. And the Russian courts have the tendency to expedite such matters. So when the day of the preliminary hearing comes, the parties appear before the court and have an almost friendly discussion. They open evidence, each of them. They also state their defense. At that time, the parties may submit petitions for injunctions, for example, or when the case is complicated, the parties may ask for technical expertise. As a rule, the judge at this stage proposes to the parties to conclude an amicable agreement. And we can understand that because the judge has much workload, and certainly if the parties at this stage agree to settle amicably, there will be less work for the judge. But if the parties are stubborn to continue their strife, the judge schedules the date for the main hearing, which again may be in a month's time or so. Now we have a very important novelty in the Russian court system. Now, Russia is a country, a very large country, and perhaps Andorra or Monte Carlo would not have such a problem. If we have an infringer, for example, in the city of Khabarovsk, and we are in Moscow, it takes almost 9 hours to fly to Moscow to Khabarovsk. And aside from the simple loss of time, it would be also very much more expensive to travel to Khabarovsk to pay the hotel expenses. Therefore, the Russian court system now has introduced a so-called electronic justice. This is a web page where we may access to the court and arrange for the electronic justice. This is how it happens. When we have a case where a plaintiff, we file a petition to participate online to the court in Khabarovsk, if it takes place there. The court in Khabarovsk, which handles the case, issues an order to participate online. In many cities, the online participation is already available, but still not in all of them. But you may be interested to learn that for the most part, infringement cases take place in large cities, and therefore large cities are most eligible for having such online court hearings. Then the commercial court, located at the place of location of the plaintiff, in our case it is Moscow, invites the plaintiff to the courtroom. The court checks the powers of the plaintiff, and then participation in the court hearing takes place as if the plaintiff were in the same room with the defendant. So you will see that this is a very comfortable system, very convenient system, which has been organized by the Russian courts. So we have already said that a preliminary injunction is possible. This is a question which is also very often asked, and we have to say that a preliminary injunction is rather often applied, but not so often granted. But nevertheless, there are many cases when indeed that preliminary injunction was granted. So what can we demand when we file for a preliminary injunction? In the first place, we may ask for the seizure of property or monetary funds so that the infringer should not place somewhere else his money from the bank. Also, we can ask the court to impose a ban on certain actions which may be done by the infringer. Or vice versa, we may ask the court that it orders to perform certain actions by the infringer. Also, it is possible that the property can be transferred to the plaintiff. Our experience shows that injunction is more frequently granted in trademark cases than in patent cases, but we have also had injunction cases when we handled cases which involve patents. So when the preliminary hearing ended in scheduling the main hearing, the court appointed the date, and on the day of the main hearing, the parties appear in court. They produce evidence. The defendant, in his turn, gives a response. He refutes perhaps the statements by the plaintiff. Then each party is given the opportunity to ask questions, and discussion is taking place. The parties have all the opportunity to state their position and prove and try to prove their attitude in court. After the issue has been discussed on all sides, the judge retires to the decision room, where he spends some time for writing the decision, and when he appears again, he announces the decision. Usually this is done verbally, and only the gist of the decision is announced to the parties, while the argumented decision, the written decision, is usually sent to the parties after several days. This is one of the very interesting cases that we had in our practice. The case concerned a patented device. This is a grain separator which separated grain from dust. The plaintiff was a foreign individual, and he had patents at the same time for an invention and for an industrial design. And at the same time, it was that several cases were initiated. At first, the administrative case was initiated. After that, the criminal case was initiated, and a civil case within the framework of the criminal case. The outcome of the cases was that, as a result of the administrative case, the court ruled to destroy the infringing machine, and this machine, it is not visible from the picture, but the size of the machine was a two-story building. The outcome of the criminal and civil case was that the infringer was sentenced to 6 months imprisonment, and he had to pay almost $500,000 US in damages. Another interesting case concerned the plasma torch apparatus. One of the companies sued another company which manufactured the same plasma torches. The case was infringement of a patent for an invention, method of plasma arc welding of metals. The expertise which was conducted in that case confirmed that the patented method was automatically carried out in the course of operation of the plasma torches of another company. But defendant stated that he used his own invention, and the difference between these two was that in the plaintiff's patent, the liquid which was used for the torches contained water with added organic solvent in the form of oxygen-containing hydrocarbon compounds. The defendant claimed that his liquid contained aqueous solution of hydrogen peroxide with added hydrocarbon-bearing fuel. Those people who understand chemistry will also understand that these two liquids are interchangeable. So the expertise also established that both mentioned features were, if not identical, but equivalent. Nevertheless, the court dismissed the case because the the court ruled that the actions of the defendant did not infringe the patent of the plaintiff. And this was considered also by the Supreme Commercial Court, which issued recommendations which were used after that in all the subsequent cases in similar situations. So that court ruled that in case where two patents contain identical or equivalent features, the use of the patent with a later priority is not considered as infringement of the earlier patent until the later patent is invalidated in the prescribed procedure. A similar attitude is also demonstrated by the courts now in case of trademark conflicts. Therefore, we always are guided by the rule. As long as the right exists for a patent or for a trademark, you can use it and you can attack the infringer. When we have such cases, we always recommend that the patent or a trademark should first be invalidated. Otherwise, this matter does not have a positive solution. Another very interesting case is patent infringement, contributory infringement. It is interesting to know that the Russian law does not have a clear-cut provision to forbid contributory infringement. In this case, the patent was granted for a cutting unit for a road building machines, which consisted of the holder and the cutter. A company, an infringing company, supplied cutters and holders for the cutters separately as spare parts, and the parts were intended to be assembled by the consumers. Since no contributory infringement was provided by the law, the court heard that case for quite a time. But in the long run, the court analyzed the law in a systemic manner and granted a judgment to the patent owner, stating that the Defendants Act created a threat of patent infringement and therefore constituted unfair competition. It should also be noted that the Russian court is not a precedent court. It is not guided by common law. Therefore, if in the future such cases are again considered by other courts or even by the same court, the decision may be quite different. But nevertheless, it was interesting to know that in such case, the court forbade the infringement, even though it did not have a clear-cut provision of the law. Now let's go to the administrative actions which are available to the IP owner. For the administrative action, we use a number of provisions contained in the administrative code. In this slide, you will see the article which concerns illegal use of copyright. And below you will see the sanctions which are applicable to such kind of infringement. Also, confiscation of pirated copies and equipment is available, and equipment can be destroyed. The same article concerns illegal use of inventions, utility models, and industrial designs. In a number of cases, there have been judgments issued in accordance with this article, and the sanctions are more or less comparable with those for infringement of copyright. They amount to slightly more than $1,000, but we have to consider that if the offense is repeated, it inevitably leads to criminal liability. Another article of the administrative code which is most frequently used by us is the illegal use of a trademark. Again, we have such claims as confiscation and destruction of counterfeit products and equipment, and also in some cases liquidation of a legal entity. In the case of administrative prosecution, we follow the same line as we discussed in civil proceedings. We conduct discovery, we buy the counterfeit goods if it is possible, we examine the counterfeit goods and collect documents of title, because when we file a suit to the court, we shall also have to provide the court with the copy of a patent or a trademark certificate. When we analyze the infringement, if we talk about patents, we have to compare the features contained in the independent claims of our patent and the features which are available in the counterfeit goods. Only if all the features coincide, then we may talk about infringement. If at least one of the features is not present in the counterfeit product, there will be no infringement in case of a patent infringement. After that, when we collect all the documents, we file a complaint with the law enforcement authority. Sometimes we organize and conduct a raid with the assistance of the police. The police will seize the counterfeit goods and place under its custody. After that, examination takes place by the experts, and administrative proceedings are conducted as is shown in this chart. First, collecting evidence approximately, it takes 1 month. Then preliminary investigation is conducted. Then a report is prepared. A report is prepared by the police, as the case may be, and the IP owner in this case intervenes as a third person. The IP owner helps the police to draft properly a lawsuit, because the police, and it is understandable, they are not great experts in intellectual property. Then the case is handed over to the court, and in a couple of weeks the court issues a decision against the infringer. As you will see, the procedure is quite swift and cheap. It is cheap because in this case the government body intervenes against the infringer and not the IP owner himself. This is one of the examples of an administrative case. Sportswear marked with a trademark was stopped by the Russian customs. After the trademark owner confirmed that the goods were counterfeit, the customs prepared a report on an administrative offense and initiated an action in court. The court found the importer guilty and imposed a fine in the amount of $400. Certainly the counterfeit goods were confiscated and destroyed, and perhaps the fine was not much, but the value of the goods for the infringer was quite considerable. It amounted to more than $300,000, and his destruction was ordered by the court. Since we have already touched briefly upon the customs, it is necessary to talk a little more about them. Quite recently, the customs union has been formed between Russia, Kazakhstan, and Belarus. The customs union allows the goods to flow freely from one country to another, and from the July 1st of the last year, the customs borders have been lifted between these countries, so that now the goods can travel freely from one country to another. Certainly it will enhance trade between our countries, but it creates certain difficulties for the IP owners. The customs register is organized in every country. The agreement between the members of the customs union provides also for the creation of a common customs register, but so far there is no such register, and it is difficult to say when it will come into being. So far we do not know when it can be. An important issue is that the customs register can include only for copyrights and trademarks. The customs do not accept patented products into the customs register, but we may say that the customs are very cooperative, and whenever we know that whenever we learn that such and such patented product may come through such and such checkpoint, the customs usually cooperate with us and they inform us when such goods come through the border, and at that time we may initiate an administrative or a civil case. I should say that the customs are exceptionally efficient now in Russia. They inform the IP owner, or rather it's his representative in Russia, and when the IP owner confirms that there is infringement, the customs initiate themselves administrative cases and hand them over to court, which rules against the infringer. As usual, the court provides for the destruction of the counterfeit products. If we talk about our law firm, we receive every week at least 40 notifications from the customs. We immediately inform the IP owner of the seizure. The customs can detain the goods for 10 days, while the IP owner has to report back whether he wants to initiate a case or not. Sometimes, unfortunately, even if the IP owner confirms that this is a counterfeit product, they prefer not to initiate a case and instruct the customs to release the goods. Perhaps this spoils the statistics of the presence of the counterfeit goods on the market, but otherwise the customs work quite efficiently. Also, when an IP owner persistently refuses to initiate administrative cases, the customs sometimes threaten to exclude the trademark or a copyright subject matter from the register, but so far they have never realized that threat in practice. We have also the option of a criminal action. The criminal code contains several articles which allow us to initiate criminal cases. In case of copyright, the code provides for plagiarism and illegal use, acquisition, and so on of copyrighted subject matter. If the same act is committed by a group, the punishment will be heavier in comparison when it is used by an individual. Another article in the criminal code which concerns patents also allow us to prosecute the infringer. Unfortunately, in case of patents, the damage, the level, the threshold is not defined. Therefore, it is to the discretion of the court whether to recognize that the damage is serious or not. If the damage is not serious, a criminal case cannot be initiated. If an action is committed repeatedly or by a group of persons, you will see here that the punishment is also more severe. And at last, Article 180 of the Criminal Code, which is probably most frequently used. It provides the threshold for initiating a criminal case at the level of $50,000 US. And if there is a case and the infringement is proved, the infringer is fined or put in prison for up to 2 years. Or if the same deeds is committed by a group of persons, that can be even up to 6 years of imprisonment and quite a considerable fine. So when we come to the administrative case, we also initiate collection of evidence. We may also conduct some search to find more evidence of infringement. There are different measures which are available to the IP owner, which may be used either himself or during the court procedures. Some measures can be taken only on the order of the court. When there is a criminal case, a civil case can be initiated within the framework of the criminal case, as I have already shown you in the example of that grain separator. So this is how it goes. The patent owner files a complaint to the police. The police goes to the shop or to a factory, seizes the infringing products. Then, if necessary, expertise is conducted by a specialist in the field. Then the report goes to the police. The crime investigator also participates in the preparation of the case, and the public prosecutor participates in the court proceedings. This is an example of a sentence, how it looks like when the court hands down such a sentence to the infringer. In this particular case, the infringer was obliged to pay a fine in the amount of $500, and the goods, you will see that the amount of the goods was quite considerable, more than 15,000 items. It was destroyed. We have also unfair competition option. In cases where IP infringement has been recognized as unfair competition, it may be protection of the infringed IP rights may be exercised either by a civil means or in accordance with the anti-monopoly law. This is specifically stated in a special article of the Civil Code Part 4. For unfair competition cases, we have the anti-monopoly law. So the following actions constitute unfair competition and are prohibited. In the first place, this is sale of goods with which infringe the rights for intellectual property. But here I would like to draw your attention to the last paragraph, which is here highlighted in big font. The fact is that several years ago, before this provision was added to the law, the trademark pirates or trademark squatters used to register the trademarks which in fact belonged to other people, but who did not, for some reason, register those trademarks in Russia. The pirates monitored the market in Russia, and they registered those trademarks in their own name. And it was difficult before the inclusion of this provision into the law to fight against those pirates. But now the number of those pirated registration has dropped drastically after this provision was included into the unfair competition law. A very important condition for being able to initiate an anti-monopoly case, an unfair competition case, is that the parties who are in the conflict should be competitors on the same market, and there should also be possible material or reputational damage to the IP owner. The cases of unfair competition are examined and considered by the Federal Anti-Monopoly Service. This is a government body, and it is competent to examine the cases in almost in the same ways as the court. As a result of the examination, they issue binding ruling for the infringer, a directive which obliges him to pay a fine and terminate and stop the infringing activities. The procedure is in some cases resembles the preparation of a case for the court. At first, the applicant files an application to the anti-monopoly body. A commission is set up consisting of 3 persons, and then after some time the application is examined by the body and a decision is issued. If the infringer does not comply with the directive of the anti-monopoly body, he may be the applicant or the plaintiff may go to court and initiate a case there. But at first the infringer is fined to the amount as you see in this slide, and the amount of fine is different depending on whether it is an individual or a legal person. This is one of the cases where the anti-monopoly body examined the case of confectionery and decided that there was an act of unfair competition. The infringer appealed the decision in court, but nevertheless the court upheld the decision of the anti-monopoly body, but only diminished the fine from 120,000 to 23,000 US dollars. There is another interesting case which we had in connection with a toy train, when the infringer practically imitated the design of the train, and again the anti-monopoly body ruled to stop that infringement. This is the description of how that case was developing. A very important case concerned junk patents. The fact is that the Russian law contains a provision that a utility model patent may be issued, and the law does not provide for the substance examination. Therefore, sometimes the so to say inventors file for devices which are known on the market for a long time. In this particular case, one of the junk patent owners filed a suit in court against 49 world-leading manufacturers and claimed 30 million or more of damages. He conducted a police raid and initiated the cases, and it was almost on the way to the court decision. The only way we could deal with this situation was that we had to invalidate that patent. The patent was invalidated and the court case was dismissed. For the sake of justice, we should say that now amendments to the law are being prepared, and most probably after several months they will be adopted by the Russian parliament, and substantive examination for utility models will be introduced in the patent office, and therefore this opportunity for the junk patents will not be any longer. So we have briefly delineated what we can do in case of infringement, and we may say complete this presentation with an English saying, where there is a will, there is a way, because we have had many cases when the patent or a trademark owner wants to stop infringement. He will always be able to do that. Now I have several questions. Who goes to jail in a patent infringement when infringer is a company? The criminal liability is only for the individuals. Therefore, if the infringer is a company, head of the company may go to prison. So here I end my presentation, and I thank you for participating in this webinar. Thank you very much, and goodbye. Overall success rates in patent cases, patent owner side. The fact is that the cases are considered on their merits, and depending on the strength of the plaintiff's position, the court will award the judgment to one or the other side. We sometimes have a question whether the foreign IP owners treated on the same basis as the Russian ones. And we always say that it does not matter for the court who is the plaintiff or defendant, because they only are guided by the merits of the case. Therefore, when we participate in patent infringement cases, I should say that in most cases we prevail over the infringers. Because when we start the case, we analyze the situation, and if we have a weak position, we explain that to our client, and if the position indeed is weak, perhaps there is no point in going to the court. I think I answered that question.